Imagine you're pregnant. Your doctor tells you that for a while, you shouldn't lift anything heavier than 20 pounds. You tell your employer, but instead of giving you lighter work, your employer says, if you can't do the lifting, you can't work. That is essentially what happened in Young versus United Parcel Service, a 2015 U.S. Supreme Court case. Peggy Young worked as a part-time driver for UPS. When she became pregnant, her doctor told her not to lift more than 20 pounds during the early part of her pregnancy. There was a problem. UPS required drivers like Young to be able to lift packages weighing up to 70 pounds. Young asked UPS to give her lighter duty work while she was pregnant, but UPS refused. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. And here's what made the situation controversial. UPS did provide accommodations to certain other workers who couldn't perform their normal duties. For example, some employees injured on the job could receive light-duty assignments. Some employees with disabilities could also receive accommodations. And certain drivers who temporarily lost their Department of Transportation certification could be given other work. Young argued, if UPS can accommodate those workers, why can't it accommodate me because I'm pregnant? UPS argued that its policy wasn't discriminating against pregnant employees. It said the company was simply following its existing categories for who qualified for light-duty work. Young eventually sued UPS under the Pregnancy Discrimination Act. The case reached the U.S. Supreme Court. So who won? Peggy Young won an important victory. The Supreme Court ruled that the lower court had been too quick to throw out her discrimination claim. The court said a pregnant worker can show possible discrimination by demonstrating that the employer accommodated other employees who were similar in their ability or inability to work while refusing to accommodate pregnant employees. The employer can then give a legitimate reason for the difference. But simply saying that accommodating pregnant workers would be more expensive or less convenient isn't necessarily enough. The court sent Young's case back to the lower court, so her discrimination claim could be considered under this new standard, and the case had an impact beyond Peggy Young herself. The lesson is simple. An employer can't automatically treat pregnancy-related work restrictions less favorably while accommodating large numbers of other workers with similar limitations. Employers may have legitimate reasons for treating workers differently, but if a workplace policy puts a significant burden on pregnant employees, the employer may have to explain why. So if you're pregnant and temporarily unable to perform part of your job, the answer isn't necessarily, too bad, you can't work. Federal discrimination law may protect you. Thank you for watching. If you enjoyed this story, watch this case next.